Hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, if you're enjoying our content, please remember to subscribe to help my channel grow. For today's case, we're dealing with police excessive force in the case of Michael McReynolds versus Officer Daryl Schmitley. In this case, the officer was very physically aggressive to someone who didn't deserve it, causing a lot of harm and problems. We're going to read this case and analyze what went wrong. Let's get started with this. During the early morning hours of June the 12th of 2012, Brenda Canina called 911 about a domestic disturbance, reporting that her boyfriend was throwing furniture. In the background during the call, McReynolds can be heard screaming. Both parties, perhaps unsurprisingly, had been drinking. Parts of the incident that followed were caught on a dash cam. Video showed that two officers increasing their pace and then jogging towards the house. While the officers ran out of view of the dash cam recorder, the officer's microphone captured the entire incident. Approximately 3 to 4 seconds after they began to jog, one of the officers is heard to say, "Stop right there, don't move, get on the ground." McReynolds stopped and turned around, but he was slow to get on the ground. McReynolds asserts any delay was a result of his intoxication, not knowing who was ordering him to get to the ground, and being in the bright light of the flashlights. The officer then more loudly commanded McReynolds to get on the ground. He dropped to his knees and put his hands in the air. Okay? So the officers are jogging at him, telling him to get on the ground, right? And he's complying. He's on his knees. 2 seconds passed, and Schmitley once again commanded him to get all the way on your stomach. He responded by saying, "On my stomach?" Without any further direction, he tackled him from behind. With a running start, the officer thrust his knee into his back and in his arm into his neck, driving his face into the pavement with great force. The force of the tackle broke his jaw in multiple places. Okay. So yeah, this might be a bit excessive. The officers are responding to a potential domestic incident. The officers are running up on the scene. They see the guy. They tell him to get to the ground. He starts to get to the ground. His knees are on the ground with his head on his stomach, his head in his hand. They say, "Get on his stomach." He says, "On my stomach?" And then, with full running force, he drives his knee into his back and his arm into his neck, driving the guy's face into the pavement, causing his jaw to break. When he's already on his knees, with his hands on his head, this might be a bit excessive. This might be a bit much. So yeah, I think we can see the problems rapidly. Snowdoubt says, "Did they ever say police?" Apparently not. So, okay. McReynolds underwent multiple surgeries to repair his jaw. Follow-up procedures ultimately involved extraction of a tooth as well as insertion of metal plates and screws. McReynolds' recovery was complicated by an infection that required repeated packaging of the wound. He suffered damage to a major nerve, which caused a permanent loss of feeling and sensation to a portion of his jaw. McReynolds was unable to work for 4 months during his recovery. So, yeah, this is some fairly serious physical injury. It sounds like his jaw wasn't so much broken as shattered, which isn't surprising because the officer's full body weight basically was forcing this guy's face into cement. So, yeah, he's lost some tooth, he's lost some nerve, and he has permanent metal implants in his face. Sounds like it might be a bit much. Okay, so we've determined what the officers have done. They have run up on a guy who is kneeling on the ground, and they have, basically drop kicked him. So now we have to figure out whether this is excessive force, and can we sue under 1983 for the excessive force? Well, let's find out. In determining whether qualified immunity shields a law enforcement officer, we ask whether the evidence viewed in the light most favorable establishes a clear violation of the Constitution that was clearly established at the time, and whether an officer would know his actions were unlawful. With respect to this first prong, when the evidence is viewed in light most favorable to McReynolds, the fact establishes the following. The officers arrived, and without announcing who they were, so they never said police, ordered McReynolds to stop and get on the ground. McReynolds did not know who they were. As soon as McReynolds realized he was being ordered to the ground by the police, he complied by getting on his knees and placing his hands up in the air. By that time, no reasonable officer could view Miss Reynolds as a threat or that he was a flight risk. One would think. At the moment McReynolds was tackled, he was compliant and neither a threat nor a flight risk. We've previously explained the use of significant force against such a suspect is not objectively reasonable. So yeah, I mean, there are excessive force cases, and this guy, again, on his knees, hands in the air. Maybe we don't need to do a running start and drop our knee into his back. Maybe a little much. The officers argue their use of force was reasonable in this case because McReynolds was not compliant. They focus on McReynolds' purported delays in complying with her initial command to stop and get on the ground. And then once on the ground, McReynolds' failure to immediately get on his stomach. McReynolds' allegedly initial and brief noncompliance is immaterial. Yeah, and it was like 2 seconds of noncompliance, incidentally, which, when drunk is pretty good. So his alleged brief noncompliance is immaterial to excessive force analysis because as soon as he realized it was police, he fully complied to get on the ground. The noncompliance ended well before this tackle. As to the purported second incident of noncompliance, prior to using force, the officers must allow a reasonable opportunity to comply with their demands, which didn't seem to happen. The whole thing was like just a couple seconds long, and he's like, not, and even if it was non-compliant, this probably still is excessive. We explain the contours of a right at issue are sufficiently clear to inform a reasonable officer in an officer's position that would be unlawful to perform a leg sweep and throw to the ground a nonviolent suspected misdemeanant who was not threatening anyone, was not resisting arrest, and was not attempting to flee. We therefore conclude that a reasonable officer would have fair warning in 2012 that they could not violently take down a person who was not threatening anyone, not actively resisting arrest, and not attempting to flee. The district court erred in granting district qualified immunity to the officer for the drop kick. Yeah. Thus, that brings us to the end of the case of Michael McReynolds versus Officer Daryl Schmidt-Litley. In this case, they came to a potential domestic violence incident, and the guy didn't know initially who the police were. When he figured it out, he got on his knees and put his hands up in the air. And then they ordered him to his stomach, and he said, "On my stomach," and in response for which, they basically shattered his jaw. And yeah, you can't do that. You can't do that because he's not a threat to anyone. He's complying, and you didn't give him enough chance. So the district court erred by granting qualified immunity. We go back to trial court to figure out what, if anything, we should do about it. And at least for the moment, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.